You slipped and fell at somebody's premises. A restaurant, a big box retailer, doctor's office. And guess what? You're sitting there on the floor, your pants are wet, and you look up and there's a wet floor sign. Oh no, I don't have a case anymore, you may think. Well, that's not true. I've represented plenty of people where a wet floor sign was somewhere out, perhaps in a completely different part of the store, plenty of feet away, perhaps even sitting on top of a portion of the liquid. But that's just part of the equation. A sign out when you fall does not mean that you are not hurt. It certainly doesn't mean that the retailer or the premises owner is not at fault. They have to warn you. The law says, Georgia law says, that a premises owner has to warn you of a hazard that they're aware of. And so they've warned you, potentially. But that doesn't mean that their warning was adequate. And that's what it has to be. The warning has to be reasonable. So, is it just one sign? Should there have been multiple signs? Should there have been signs surrounding the area where you fell? Did you pass a sign walking into the wet area, or was the sign beyond where you slipped and fell? All those are questions that need to be answered before you can know whether or not you still have a case. And we're happy to answer those questions for you, which is all the more reason that when you fall, if you fall, get a picture of that wet floor sign. Get a picture of where that wet floor sign was in relation to the area where you fell. It's incredibly important to knowing whether or not the retailer or the premises owner did what they were supposed to do. Did they use ordinary care? And we'll be able to give you some guidance in answering some of those questions. So if you have any questions about a wet floor sign that was out or multiple wet floor signs that were out, give us a call. We'd be happy to answer those questions for you.